Right now, somewhere in America, a law-abiding citizen is being pulled over by police. They have a concealed carry permit. They have a firearm lawfully in their vehicle. And in the next few seconds, they will face a situation that millions of gun owners encounter every year. The question of what to say, when to say it, and how to say it is not as simple as most people assume. The Supreme Court recently issued a landmark 6-3 ruling that has reshaped the legal landscape for gun owners across the country. But what the court actually said and what it means for your rights during a police encounter is being widely misunderstood. This video cuts through the noise, the misinformation, and the political spin to give you the precise legal breakdown you need. By the end of this video, you will understand exactly what the Supreme Court ruled and why it matters, what the ruling does and does not change about your legal obligations when interacting with police, how different state laws create different requirements depending on where you live, what constitutional experts and defense attorneys actually recommend in these situations, and what developments to watch for in the coming months as lower courts apply this ruling. This is not political commentary. This is not fear-mongering. This is the actual state of the law as it exists right now, explained clearly and precisely, so you can make informed decisions the next time you find yourself in this situation. The Supreme Court decision that has generated all of this discussion is called New York State Rifle and Pistol Association, incorporated against Kevin Bruen, who was the superintendent of the New York State Police at the time. The case is commonly referred to as NYSRPA versus Bruen, and it was decided on June 23, 2022. The decision was a 6-3 ruling along ideological lines, with Justice Clarence Thomas writing the majority opinion. This was the court's first significant Second Amendment case in over a decade, and it delivered a clear and sweeping statement about the scope of the constitutional right to bear arms. Here's the background of what the case was actually about. New York had a law that required anyone who wanted to carry a concealed handgun in public to demonstrate to the satisfaction of a licensing official that they had a special need for self-defense. This was known as the proper cause requirement. The state courts had interpreted this requirement to mean that applicants needed to show more than a general desire to protect themselves or their property. Instead, they had to demonstrate a specific, particularized need, such as a documented pattern of threats, a profession that put them at elevated risk, or some other exceptional circumstance. Ordinary citizens who simply wanted a firearm for general self-defense could be denied a license under this standard. Two New York residents, Brandon Koch and Robert Nash, applied for unrestricted concealed carry licenses, citing their interest in self-defense. Both were denied. They sued, arguing that New York's requirement violated their Second Amendment rights. Their case eventually reached the Supreme Court. If this breakdown is useful to you, subscribe now and hit the notification bell so you do not miss our ongoing coverage of this area of constitutional law. The legal landscape is shifting rapidly, and the next development in this story could be significant for anyone who exercises Second Amendment rights. Turn on notifications and stay ahead of the curve. Now let's go deeper into what the court actually ruled and why it matters so much. The Supreme Court's ruling in Bruen was comprehensive, and it changed the legal framework for evaluating gun regulations in fundamental ways. Justice Thomas began by confirming what had already been established in earlier cases, District of Columbia versus Heller in 2008 and McDonald versus Chicago in 2010, that the Second Amendment protects an individual's right to possess a firearm for self-defense. But then he went further. He wrote that this right extends beyond the home. The Second Amendment's reference to the right to bear arms, he explained, most naturally refers to the right to carry a firearm outside the home for self-defense. The text of the amendment does not draw a distinction between home and public carry, and neither should courts. The most significant part of the ruling was how the court changed the analytical framework for evaluating gun regulations. Before Bruen, lower courts had been using what was called a two-step approach. First, courts would ask whether the conduct being regulated fell within the scope of the Second Amendment as originally understood. Second, if it did, courts would ask whether the regulation was sufficiently tailored to serve an important government interest, applying some form of means-end scrutiny. This approach gave courts considerable latitude to balance the benefits of gun regulations against their burdens on individual rights. The Supreme Court rejected this framework decisively. Justice Thomas wrote that the two-step approach had one step too many. The proper test, he explained, is simpler. If the Second Amendment's plain text covers an individual's conduct, then the Constitution presumptively protects that conduct, and the government bears the burden of demonstrating that the regulation is consistent with the nation's historical tradition of firearm regulation. Historical analysis, the court said, is more legitimate and more administrable than asking judges to make difficult empirical judgments about the costs and benefits of firearms restrictions, especially given their lack of expertise in the field. This shift matters enormously because it changes which side bears the burden of proof and what kind of evidence can justify a restriction. Under the old framework, governments could justify gun regulations by showing that the regulations served important public interests and were reasonably tailored to achieve those interests. Under the new framework, governments must show that their regulations have historical roots, that similar restrictions existed when the Second Amendment was adopted in 1791, or when the 14th Amendment was adopted in 1868. Modern policy justifications do not carry the same weight. If a regulation cannot be supported by historical precedent, it is unconstitutional, regardless of how reasonable it might seem to modern eyes. Justice Thomas spent a significant portion of the opinion examining historical sources spanning nearly 7 centuries, from the late 1200s through the early 1900s. He identified categories of restrictions that have historical support, including laws forbidding carrying in sensitive places like courthouses, polling places, and schools, laws prohibiting possession by felons and the mentally ill, and laws regulating the commercial sale of arms. But he also concluded that there was no historical tradition of requiring ordinary law-abiding citizens to demonstrate a special need for self-defense before carrying a firearm in public. New York's proper cause requirement, he wrote, had no basis in historical tradition, and therefore violated the Constitution. The majority drew a striking conclusion about the nature of the right. Justice Thomas wrote that the constitutional right to bear arms in public for self-defense is not a second-class right subject to entirely different rules than the other Bill of Rights guarantees. He emphasized that no other constitutional right requires individuals to demonstrate some special need to government officers before exercising it. You do not have to show a special need to speak freely, to practice your religion, or to be free from unreasonable searches. The Second Amendment right to carry arms in public is no different. Drop your thoughts in the comments below. Do you think the historical test established in Bruin is the right approach for evaluating gun regulations, or should courts consider modern public safety data when making these determinations? This is one of the central debates in constitutional law right now, and your perspective helps shape how we cover these issues. While you are thinking about that, consider how this ruling affects the practical question of what to say when you encounter police while armed. Understanding your legal obligations when you are carrying a firearm and encounter law enforcement requires separating several distinct legal concepts that are often conflated. The first concept is the constitutional right to carry, which the Bruin decision confirmed exists and cannot be denied based on arbitrary criteria, like requiring a special need demonstration. The second concept is your state's duty to inform law, which is a separate legal requirement that varies significantly from state to state. The third concept is your Fifth Amendment right against self-incrimination, which protects you from being compelled to provide testimony that could be used against you in a criminal case. And the fourth concept is your Fourth Amendment right against unreasonable searches, which limits when police can search your property without consent or a warrant. Here is where precision becomes essential. The Bruin decision addressed whether states could require special cause demonstrations for concealed carry licenses. It did not directly strike down or modify state duty to inform laws. These are separate legal questions. Duty to inform laws require gun owners to proactively disclose that they are armed during a police encounter, either immediately upon contact or when directly asked. These laws exist in various forms across the country, and the Supreme Court's ruling in Bruin did not eliminate them. Some states require you to announce your armed status as soon as an officer makes contact. Some states only require disclosure if the officer asks directly. Some states have no duty to inform requirement at all. The consequences of getting this wrong can be serious, including criminal charges even when your possession of the firearm would otherwise be lawful. The Fifth Amendment adds another layer of complexity. The right against self-incrimination means you cannot be forced to provide testimony that could be used against you in a criminal prosecution. But this protection is not absolute, and it does not apply in all circumstances. If an officer asks whether you have a firearm and you are in custody or under official compulsion to answer, your silence potentially has constitutional implications. However, if you voluntarily answer the question, you are not being compelled to testify. And if you are not in custody, the Fifth Amendment may not apply at all. The distinction between voluntary statements and compelled testimony is often blurry in practice, which is why legal guidance on this point tends to emphasize knowing your state's law and making careful tactical decisions based on the specific circumstances you face. What constitutional scholars and defense attorneys generally recommend in these situations follows a consistent pattern. Know your state's specific duty to inform law before you ever carry a firearm. This is the foundation of everything else. If your state requires proactive disclosure, you must do so immediately and clearly. If your state only requires disclosure when asked, you still must answer honestly if directly questioned. Lying to a police officer about having a firearm when asked can expose you to charges of obstruction or making false statements, and those charges are not protected by the Second or Fifth Amendments. The practical recommendation is to use clear, precise language that establishes your lawful status and invites the officer to provide guidance. Something like, "Officer, I want to inform you that I have a lawfully possessed firearm in the vehicle. I have a concealed carry permit. I am not reaching for it without your instruction." This language accomplishes several things at once. It demonstrates transparency and cooperation. It establishes that your carry is lawful. It avoids surprising movements by explicitly saying you will not reach for the firearm. And it invites the officer to give you instructions on how to proceed safely. Throughout the encounter, keep your hands visible at all times. Do not reach for anything, including your registration, insurance, or identification, without first telling the officer what you are going to do and getting their acknowledgement. If the officer asks you to step out of the vehicle or wants to secure the firearm for the duration of the encounter, comply promptly and without argument. These are within their authority in most circumstances. You can challenge the legality of their actions later in court with the help of an attorney, but on the street during an active encounter, the priority is de-escalation and compliance. The Bruin decision also clarified what kinds of gun regulations remain valid after its ruling. The court explicitly preserved several categories of restrictions that have historical precedent. Long-standing prohibitions on possession by felons and the mentally ill remain constitutional. Laws forbidding carrying in sensitive places such as schools, courthouses, and government buildings remain constitutional. Laws imposing conditions and qualifications on the commercial sale of arms remain constitutional. What the court struck down was the specific type of restriction that conditioned the exercise of the right on demonstrating a special need to a government official. This is an important distinction because it shows that Bruin did not eliminate all gun regulation. It clarified which kinds of regulation are permissible and which kinds are not. States can still regulate, but they cannot regulate in ways that effectively deny the right to ordinary law-abiding citizens based on arbitrary or discriminatory criteria. Justice Thomas was careful to note that historical analysis can be nuanced, and that not every modern regulation needs to be an exact replica of a historical precursor. Courts can use analogies to long-standing restrictions to evaluate modern regulations that address similar concerns. But the basic framework is clear. If a regulation cannot be connected to historical tradition, it is unconstitutional under the Bruin standard. The dissenting justices, led by Justice Stephen Breyer, raised significant concerns about the practical effects of this ruling. Justice Breyer noted that over 45,000 Americans were killed by guns in 2020, and he argued that states should retain flexibility to craft regulations that address modern public safety challenges. He faulted the majority for striking down New York's law without a sufficient evidentiary record about how the regulation actually worked in practice. The dissent argued that democratic processes should have room to address gun violence through legislative solutions, and that courts should give some weight to legislative judgments about the costs and benefits of different approaches. Justice Samuel Alito wrote a concurring opinion that was sharply critical of the dissent's framing. He pushed back against the idea that the ubiquity of gun violence in America was a reason to sustain New York's licensing scheme. His point was that people seek the right to carry firearms precisely because of dangerous conditions, and the Second Amendment protects their ability to do so. Just as in 1791, he wrote, "Many Americans today have good reason to fear that they will be victimized if they are unable to protect themselves. The right to bear arms exists precisely to address that legitimate concern." Justice Brett Kavanaugh wrote separately, joined by Chief Justice John Roberts, to emphasize what he characterized as the limited scope of the ruling. He noted that 43 states use licensing schemes that include objective requirements like background checks, firearms training, mental health record checks, and fingerprinting. These schemes are constitutional, he explained, because they are objective rather than discretionary. They do not grant licensing officials open-ended discretion to deny applications based on subjective determinations of need. What states cannot do is require applicants to demonstrate some special need beyond ordinary self-defense. That is the line Bruin drew. If you found this breakdown valuable, subscribe for our ongoing coverage